During opening arguments in your medical malpractice trial, can I tell the jury what the claims are against the doctor and the hospital? Am I permitted to tell the jury what the law is as it relates to your particular case? You want to know the answer? Come join me on this walk through the neighborhood as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is yes, I am permitted to tell the jury exactly what our claims are against the doctor and the hospital whom you have sued. It is critically important during opening arguments to explain to the jury exactly what our claims are. You know why? Because if I fail to tell the jury exactly what our claims are, when I am done with my opening argument, the defense attorney will jump up out of his seat and before giving his opening argument, will turn to the judge and say, "Judge, I ask that you dismiss Oginski's client's claim." Why? Because he has failed to make out a prima facie case. Now what does that mean? It means I have failed to lay out for the jury exactly what our claims are against the doctor and against the hospital. And if I have failed to do that, then you know what? Then there is a very real possibility that the judge will turn around before opening arguments have been completed and dismiss your case. All because I have failed to lay out for the jury exactly why we are here, why we believe the doctor was careless, why we believe the hospital staff was careless and caused you significant harm and injury, and what those injuries are. It is actually required that an attorney representing an injured patient who brings a lawsuit against the doctor and the hospital at the time of trial during opening arguments, that we go ahead and actually lay out in detail exactly why we believe that we are entitled to a verdict in our favor. If we don't, we run the risk that the judge will throw our case out for failing to make out a prima facie case, which means that we have failed to explain to the jury all the elements necessary to go forward with this claim, to go forward with the trial. So, let's go back to the question I raised in this video. The question was, not only can I go ahead and tell the jury what our claims are against the doctor and the hospital, but I also asked the question, can I tell the jury what the law is in New York? And the answer to that question is not really. Now, at the beginning, I said yes. Well, no, actually, the answer is not really. Now, let me tell you what I mean. We are prohibited, the attorneys are prohibited, from telling the jury explicitly what the law is in New York. Why? Because that is the judge's function. The judge is the one to tell the jury exactly what the law is. The judge, at the end of the case, will explain to the jury in detail what the law is in relation to our particular case. The attorneys are not supposed to go ahead and explain to the jury what the law is or how this case applies to the law. We save that for closing argument. When I said at the beginning, yes, we can go ahead and tell the jury, the reality is we can explain certain concepts to the jury, but we are not permitted to tell them the actual law. The judge does that. So when I say we can tell them about concepts, well, there's a concept, for example, known as falsus in uno. And what does that mean? It means that if a witness has lied about one little thing, the jury has the right to disregard some of their testimony or all of their testimony. So I couldn't come right out during opening arguments and say, ladies and gentlemen, you're going to find that one of the key doctors in this case lied. And you're going to find at the end of the case that if you find that this guy lied, there's a concept in law known as falsus in uno. And that means you can go ahead and disregard some or all of his testimony. No, no, no. I'd get an immediate objection from the defense attorney saying that I can't argue the law. Why? Because that is the judge's function. So instead, I can go ahead and give the jury some sort of explanation about what it means to lie in a case like this. Ladies and gentlemen, we are going to show you proof. We're going to show you that the doctor in this case lied. And you'll have to evaluate the veracity, the credibility of this particular witness. So I can go ahead and begin seeding those concepts and those ideas to the jury so they begin to recognize immediately that this doctor has lied. He's lied throughout the course of this lawsuit. And now when he gets on the witness stand to testify, hopefully on the witness stand, hopefully I'll be able to expose some of those lies. And then at the end of the trial, that's when I can highlight to the jury, ladies and gentlemen, you heard this doctor tell you various things that were untrue. I can now highlight to the jury those various lies and show them how the doctor clearly violated the standard of care and how he contradicted himself multiple times. And then I can explain the concept of what we call falsus in uno without actually saying it. I said, ladies and gentlemen, you're going to hear from the judge in just a few minutes tell you that if a witness is found to have lied about one little thing, how can you trust what he has to say about all his other things? Which means you can disregard some of his testimony, you can disregard all of his testimony, but pay attention to what the judge tells you with regard to lying. So getting back to the title of this video, can I go ahead and lay out our claims during opening argument? Absolutely, it's something that I have to do. Can I go ahead and explain the law to the jury? Well, not explicitly, absolutely not, and I wouldn't want to spend a great deal of time doing that anyway during opening arguments, because this is my opportunity to explain to the jury exactly why we're here, exactly why we believe the doctor was careless, causing you significant harm and injury. You know, I realize you're likely watching this video because you wanted to see the beautiful fall scenery here. No, I realize you're likely watching it because you have questions or concerns about your own matter. Well, if your matter did happen here in New York, and you're thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a great day.